Returning speaker.
That's right, yes. Well, welcome everybody. And big hand for Dr. Phil over there. All right, there he is as he exits the room. That's the perfect time to clap. Anyhow, welcome everybody. My name's Alex Rebellis. I'm an attorney with the Blackstone Law Group. We practice out of New York. We focus on information security. And we also run a separate entity that actually is an information security consultancy itself, but only operates through our law firm for legal privilege purposes. So one of the things we're going to talk about today, welcome, is this ongoing battle between Cox Communications and BMG Rights Management. This is a lawsuit that has been percolating, come on in everybody, up the and through the legal system literally since November 2014. And it's very interesting because it has to do with an internet service provider's liability for copyright infringement. So all the terrible crap that we do can end up in the lap of an internet service provider if they're not careful. And that's exactly what happened in this particular case. So what we will do is step through who the players are, talk about the legal claims, talk about the Digital Millennium Copyright Act, which I'm sure many of you have heard before. And we're going to talk about how Cox lost immunity under the Digital Millennium Copyright Act as an internet service provider. And specifically, we're going to go through a bunch of really idiotic internal emails that Cox had written and sent amongst its trust and abuse employees. And those were the emails that actually caused them to lose this immunity. And then once we get through that, we will then venture onto this brave new world of copyright infringement technologies, namely streaming services and Kodi and its various unauthorized add-ons. So let's talk about this. Let's talk first about the players. So the players in this particular case are BMG. People have probably heard of BMG here. You know, they represent artists. They essentially manage copyrights for a huge number of artists, and specifically music as well. And as you can tell, they are a very hip company. They've got tattoos, they have coffee, and some of their older employees even read magazines. So yeah, BMG is the plaintiff in this particular case. But more to the point, however, BMG is the plaintiff, but the evidence that BMG presented in this particular lawsuit all came from a company known as Rights Corp. And if you haven't heard of Rights Corp, what they do is they troll hundreds of thousands of different torrents for copyrighted material. And then they begin to tag them and they track them. And then Rights Corp sends notifications over to an internet service provider that, let's say, this guy with the Virginia Tech t-shirt over here downloaded Enter Sandman 20 times last night, and now he's about to be sued, or he can pay a nominal settlement fee of, let's say, $10 to $20 for his copyright infringement. And what well, we'll get into this, but essentially they sent hundreds of thousands of these notifications over to Cox Communications, and it became really difficult to deal with, so they just stopped dealing with them. So the evidence that BMG presented really came from Rights Corp, but BMG is the plaintiff here because they represent the artists. And the other company, the defendant, is Cox Communications. And they are a major ISP in the Mid-Atlantic area. They've got about 3.5 million subscribers in the United States for internet service. And they are, I believe, the third largest ISP in the United States. And we will show you why they live up to their name. He got it. Okay, there he goes. All right. So this is the caption of the case. BMG Rights Management LLC and Roundhill Music LPV, Cox Communications Inc. and Coxcom. This is in front of Judge Liam O'Grady, who is a federal district court judge who sits in Alexandria, Virginia. And what happened here? So, like I said, this was filed in 2014 in November. Whole bunch of copyright claims found by Rights Corp. 2.5 million copyright violation notifications sent over to Cox. As we had mentioned in our example, $10 to $20 per violation. And Cox began to ignore those violations because they claimed that this business model, which is contingent upon extracting settlements from individual copyright infringers, doesn't necessarily comport with the spirit of the Digital Millennium Copyright Act. So we're just going to ignore this. And of course, Rights Corp and BMG, they don't like this. So, they were bored, so they decided that they would probably, let's try this out. Let's try to sue an internet service provider for contributory copyright infringement. And contributory means, the trick is in the name, that you are contributing to it. You're not the direct infringer. You're not the guy in the Virginia Tech t-shirt downloading Enter Sandman. You are his ISP. And in fact, an ISP could be Bloomsburg University. They could be also considered to be an internet service provider. So, these are the claims. In this particular lawsuit, there were really only about 1,400 songs at issue. And Cox invoked the DMCA safe harbor provision. And then they lost that. And so what safe harbor basically is, it says if you're an internet service provider, you cannot be held responsible for the content that's going through your network. You're a mere conduit, right? It would be the equivalent of you going and buying a car at a car dealership, and I was going to say crashing it into a bunch of people, but maybe that's a bit too soon. But, causing a major accident, and then somebody suing the car dealership from which you bought the car. They just gave you the car. We just give you internet service, so you do what you want at your own peril. But you only have that particular defense if you comport with certain reasonable means of notifying others of copyright violations. So there's a 2-week trial. And as we mentioned, Cox lost this immunity. And eventually this ended up in a verdict against Cox for contributory copyright infringement. So this has never happened before. It's a completely new case of first impression. And it has terrified internet service providers throughout the country because they think they could be next. So DMCA safe harbor. In particular, 17 U.S.C. section 512. This immunity is only going to apply to service providers. As I noted, you have to cooperate with copyright owners to address this type of infringement. And most importantly, the policy has to be reasonably implemented. And that's what was found to be lacking in this particular case. So this is how Cox lost it. Like I mentioned, idiotic internal emails. So let's take a look specifically at the person who is responsible for the loss of the safe harbor immunity. It is unfortunately, and this is very rare for a federal judge to do, literally point out one particular person in an opinion over and over and over again and quote his emails. And honestly, I feel really bad for this guy, Jason Zbec, because his name is all over this. You can't Google it without seeing a load of crap about this poor guy. So the judge had said, even viewed in the light most favorable to Cox, the court finds the contents of the emails cannot be explained away. That's pretty bad. So I'm setting this up, and I hope you find this really bad too. So Jason Zbec, after this opinion came out, he did keep his job at Cox for a long time, and he was essentially in charge of anti-abuse operations, the trust and abuse type squad they had over there. He did leave fairly recently, and we'll show you to where he went later on. But these particular emails, so this is an actual email from Jason Zbec, and I'll read to you some choice bits from this. With this in mind, as we move forward, this is challenging times. We need to basically make money. With this in mind, if a customer is terminated for DMCA, you are able to reactivate them after you give them a stern warning about violating the acceptable use policy and the Digital Millennium Copyright Act. We must still terminate in order for us to be in compliance, but once termination is complete, we have fulfilled our obligation. After you reactivate them, the DMCA counter restarts. And then specifically underlined in red, this is to be an unwritten semi-policy. Well, a lot of you guys are still in college. Some of you are not. The guys in the suits over there hopefully aren't. But here's a little bit of advice, unsolicited legal advice. If your company has an unwritten policy, don't put it in writing. Okay? I mean, it's very simple. It's not that difficult to figure this out. If you say it's an unwritten policy in an email, then it's a written policy and you're screwed. Okay? And it costs them a lot of money. I'm not saying put your head in the sand and allow a company to do something untoward. There's a reason why whistleblowing lines exist. I used to run one for a huge company, in fact. But if you're going to comply with the unwritten policy, don't write it down, for Christ's sakes. So an RGU, there's another one that the judge found very interesting. An RGU is actually a customer. But this is what Cox, this acronym that Cox has generated for its own customer base, or revenue generating units. You don't have names. You don't even have customer IDs anymore. You're simply a revenue generating unit. And the interest that Cox had in making money is also something the judge found to be really sort of inimical to the spirit of compliance with the safe harbor provision of the DMCA. So, also it's interesting to note here that Jason does distinguish between, DOS attacks, spam, and hacking, and copyright violations, claiming that, well, look, copyright is not really a big deal as well. So the judge probably didn't like that, in my opinion. So here's another one. Another internal email. Internal info only. Do not forward. Well, that doesn't matter in litigation. It's going to be produced, unfortunately. And again, going back to the monetary interest that Cox has, this way, he says, we can, basically returning a customer to service after they've been terminated, and then make one phone call back and say, why is my service terminated? And they say, well, you downloaded some songs. Now that you've called, we'll turn you back on. But again, they're talking about money. This way, we can collect a few extra weeks of payment for their account. And then a little winky smiley. And here's a little bit more unsolicited legal advice, that federal judges don't like winky smileys. Okay? That's not a good idea to have in any of your communications about sketchy stuff. So, some more strange emails from Jason Zbec, right? Straight down to the end of this paragraph. I mean, he literally writes DMCA equals reactivate. That is horrible. That's like diametrically opposed to what you are supposed to be doing. And then at the end, you can make him wait a day or so if you want to reactivate his service. And again, with the winky smiley. So I can only imagine that judge hated this winky smiley here. Bad idea. Okay. I mean, they're just generally not professional to begin with, but, in this context, particularly bad. So the other thing that Zbec probably should have known better about was that he talked about this a lot in instant messages. Just to be clear, this particular "you're just jealous because we're young and in love" that's not from him. That's just an example. Wouldn't be surprised though. But they talk here in instant messaging channels about soft terminates. And soft terminate means you're going to return them back to service. Basically a suspension that is called a termination with a likelihood of reactivation, namely all of their customers. But I think, here's an important point too, for people that are going to be joining the workforce, is that instant messages are still part of litigation. They can still be discovered very, very easily. Don't think because you're not on official email that all your communications are not going to be discovered. As we see here, all of this is going to end up in litigation. A lot of companies are using Slack. All of that can be retained. And in fact, a couple of weeks ago, Slack just released their enterprise version. And not surprising, with the enterprise version of Slack, there is a lot more functionality with respect to the retention of information. If you work for any kind of financial institution, any kind of bank, trading institution, and anything that has to do with finance that's regulated by the SEC or any state agencies, insurance companies, all of those communications, whether they are internal or external, will very, very likely be logged. Unless you're on your own device and you're using some kind of encrypted end-to-end communication protocol, something like Wicker, Telegram, Signal. But even then, if the litigation gets hairy enough, as I've had a couple different investigations, and specifically with programs like Silent Circle, even if the messages themselves are burned, there will still be little traces in the database of the messages about when they were sent and to whom. So you can still collect metadata, and that metadata can be very damning. So, again here with the instant messages, really bad stuff. Under the table procedure, the kind of stuff that you really never want to put in writing. So, eventually, after the judge had ruled on the basis of these idiotic internal emails that Cox was no longer entitled to the safe harbor immunity defense, this went to a 2-week trial. And this is the actual verdict form. And we will step through this process. So, what was presented to the jury was essentially a series of questions, and we'll go through 3 of these questions. So we, the jury, in the above captioned action, answer the questions submitted to us as followed. Direct infringement. Did BMG prove by a preponderance of the evidence that users of Cox Internet Service use that service to infringe BMG copyrighted works? That's a long-winded way of asking, did anybody on Cox's network download copyrighted material? So that the answer is not really surprisingly yes, of course, right? But this is the first step in the uh-oh. Contributory infringement. This is where it gets a lot more difficult for Cox. Did BMG prove by a preponderance of the evidence that Cox is liable for contributory infringement of BMG copyrighted works? And I'm sure that they needed to change their rubber pants when they saw the answer yes. That is not good. And willfulness, very bad. This is a precursor to damages. Did BMG prove by a preponderance of the evidence that Cox's conduct was willful? And the basis of the willful finding had to be those idiotic internal emails. And the answer was yes. So this is where it gets bad. And then damages. What's the total amount of statutory damages that you award to BMG? $25 million. That's a lot to be out of pocket, especially if you're a smaller ISP. Cox at 3.5 million subscribers, they could absorb this and just rebill it back somehow and some unnecessary tax or charge to their customers more likely. But, you know, the smaller ISPs like we have here in Pennsylvania, I'm not sure if it's Blue Ridge here in Bloomsburg, but at my place a little farther east of here it is, and that would be very tough for them. So, yeah, this was bad. So, Jason actually moved on last year, about 6 months ago or so. He finally left Cox, and he became an associate director of cybersecurity at IIT. I didn't know what IIT was, but I was a little interested to learn that it was actually a veteran-owned small business specializing in critical infrastructure protection. You would think with a mouth like that he would be working for a Senate Select Committee on Intelligence, but no such luck. Instead, he's protecting critical infrastructure. All kidding aside, though, I think I do feel bad for this guy, Zbec. I think he's got a really bad rap, but he did some really silly things, and I think it's going to be very difficult for him to ever recover his career entirely. So it is something really to think about. So the implications of this are definitely far and wide. I hate to use that platitude, but I just did. But like I mentioned earlier, ISPs are going to be very concerned about contributory liability. This case, not surprisingly, is on appeal at the moment in the Fourth Circuit. And there are several amici curiae, or friends of the court briefs. And the EFF filed a particular amicus brief. The thrust of it, essentially, the EFF's brief was actually very interesting in the sense that they didn't take a position as to whether or not one party or the other should win. But they wanted to caution the Fourth Circuit panel reviewing the case that the termination of somebody's internet service, could have could cause great damage to an individual user, especially when it comes to economics. If somebody is reliant on this for their job, if they're reliant on this for education, if they're reliant on an ISP for their children, things like that, just willy-nilly shutting off customers' internet service is a really bad thing that should be flexible enough to account for something like the DMCA. And that they really didn't take a position one way or the other as somebody who should win, but judges need to give this a great deal of thought. And then you saw a lot of other briefs from places like library associations and universities that are concerned with contributory liability, causing them essentially to provide to its users a limited form of full internet access that would prevent people from doing certain types of research, certain types of analyses, that would essentially be filtered by some kind of required content filtering system for copyrighted materials. So also some of the implications we're seeing is that document retention policies for ISPs, namely, that's a fancy way of saying how long do you have to hold on to damaging emails, like Jason's. So I am sure that document retention policies have been revised several times in light of this particular decision. And we may see more short-term compliance with these demand letters from Rights Corp, more forwarding over to the actual users, and then some legislative implications. But more to the point for today, this particular case, BMG v. Cox, had to deal with torrents. And the brave new world of copyright infringement these days is going to be through streaming services, and namely a lot of things like the Kodi add-ons. We're talking about Exodus, Phoenix, Salt, that kind of stuff. So, other implications here, this could reach over to hosting providers, anybody who is a website host, right? The same legal reasoning can actually apply to them. It can also apply to people or organizations like Cloudflare, who operate content distribution networks, because Cloudflare, if they have knowledge that somebody is using their networks to engage in a distribution of copyrighted materials, then they may be on the hook. They're considered an internet service provider under the DMCA, but if you turn a blind eye to what your users are doing, they could see their immunity stripped from them. And we deal with a lot of copyright enforcement stuff as well within our firm, and takedowns and whatnot. And we have seen quite a lot of people, big website distributors for, in particular, PDF versions of books, hiding behind Cloudflare because they think it's going to mask who their host is. So, and then trust, safety, and abuse teams are going to be redoubled, and you're definitely going to see more nasty grams from lawyers. So let's talk specifically about Kodi. So Kodi, by show of hands here, how many people have used Kodi? So quite a few of you. And is there anybody, well, let me explain. I won't cause anybody to raise their hand if you don't know what Kodi is. But Kodi is essentially, if you don't know what it is, it's essentially a media player. And it can be side-loaded on any number of different devices. The most popular one over the last, I would say, year is probably an Amazon Fire Stick that you can buy for about $30. You side-load Kodi on it, and it's a really great media player. It used to be called XBMC. It's got a really simple, elegant user interface, and it's incredibly easy to side-load, once you have Kodi loaded, a whole bunch of unauthorized add-ons. Things like Exodus, Phoenix, stream all the sources, salts, Movie HD is a new one that I think is pretty effective. But what these allow you to do is identify all these different servers that stream copyrighted material. And it's incredibly efficient. It really, really is. I know people that work in the cable industry in DMCA enforcement, and they use Kodi all the time at home because it's just simpler to use than turning on your cable box and navigating around, HBO, DirecTV, all this nonsense. The user interfaces for things are so disparate and far and wide that Kodi allows you to have everything in one spot. So many people are using it, and it's a really great program. And one important point here is that Kodi is just a media player, and it has taken great pains to disassociate itself from the actual work of the infringers. And it's mostly streaming. And I say this in this particular bullet point because I have found out recently that sometimes some of these Kodi add-ons, they look as if they're streaming, but they're actually torrenting. So, streaming from Netflix, let's say if you're sniffing packets, it's not going to look all that dissimilar, except the source IP is going to be different, obviously, between streaming from Netflix and streaming from Exodus. So, Kodi right now is a much bigger problem for the ISPs because there's sort of people are turning their backs on torrenting to a very large extent, and you have ordinary users, people that wouldn't normally torrent, that are using Kodi for all of their media resources. So this is a really big problem, and they're not really quite sure how to handle it just yet. So, some proactive measures here. As a little shout out to the Huskies here. Revision and strict compliance with EULAs, the end user license agreements. We know that a lot of the discussions about DMCA policy internally at ISPs are going to involve internal and external counsel. So all of the stuff that Jason Zbec put in emails that were discovered, if a lawyer was involved in that and they were thinking about this from a compliance perspective and the perspective of maintaining their safe harbor immunity, it would have been very simple to protect all of those emails. All they would have had to do is copy an external counsel, and they would have had a reasonable means by which to claim legal privilege. So all of these internal discussions about DMCA compliance are going to be protected by legal privilege these days, or at least a claim of it, I can imagine. Some of the things that we're probably going to see is, limiting bandwidth, suspension of curious protocols, blacklisting of repeat offenders, possibly between ISPs, if you're lucky enough to live in a destination that has several ISPs, and the identification specifically of unwritten policies. But this is generally the stuff that ISPs should be doing anyhow. So some reactive measures, reviewing and revising DMCA internal procedures, taking more account of the Rights Corp demand letters, and collecting and retaining data about users for extended periods of time. And that will vary and does vary between ISPs at the moment. In Europe, there was something called the Data Retention Directive that many years ago I wrote a dissertation on, that is actually struck down by the European Court of Justice as violating privacy rights within the EU. So in the United States, we have never had a legal requirement to preserve data, but ISPs may actually engage in that to cover their own butts. And I think what we're definitely going to see is a revision of privacy policies, and this may also depend in large part on how the Fourth Circuit appeal turns out, but to actually permit collection of data with respect to its customers a little bit more freely. And even things like deep packet inspection. So ISP monitoring. And by the way, we are not only a law firm that understands information security, but we are also available for graphic design. I don't know if you're like that, but we're fantastic at a lot of things. Monitoring bandwidth usage and protocol monitoring, I think because people are turning their backs on torrents, are going to be of limited utility these days. But again, logging, device tracking in particular, and enhanced traffic analysis via deep packet inspection is where this sort of has to go if we're going to talk about real compliance with the DMCA and the demands of the MPAA, the Motion Picture Association of America in particular. But DPI is really expensive to implement and very, very difficult to scale. So there's a couple alternatives that I've come up with as to how this could actually work. So you don't necessarily need deep packet inspection to look at the IP and the TCP levels. But if you're going to look at application level data, you do need that. And it's a lot tricky. It's more expensive and time consuming. But so it'd be very easy for an ISP to, let's say, monitor traffic for connections to repositories, Kodi repositories, and in particular repositories through which you download offensive Kodi add-ons. And then monitor connections to endpoints that are known to host servers for Exodus, Salt, or servers that they use. I wouldn't say that Exodus hosts its own servers, but they know where these servers are located. And then once you have a listing of these particular customers that are connecting to these particular endpoints, then you start to track their MAC addresses. And then you take a look at whether the customer ever has a history of copyright infringement. Have they ever been sent a notice? Have we ever, like Zbec had suggested, have we ever shut off their internet service and then turned it back on a day later? And this would be the best of all possible worlds, I think. In all likelihood, a risk profile would be assigned to this person. It's almost like an insurance evaluation. It was a part of an underwriting process. So let's say you assign a risk level to them on the basis of 0 to 10. And if the rating is greater than or equal to 7, then utilize deep packet inspection with respect to this particular customer. So very targeted use of deep packet inspection. And then if it is found that this person is infringing copyrights by streaming movies or engaging in a theft of service by streaming movies, then you would have some sort of enhanced DMCA enforcement activity against this particular user, up to and including termination of their account for repeat offenders. Now, alternative number 2, though, is a little bit scarier because it would involve widespread monitoring. So we could see an ISP revising its EULAs and its privacy policies to permit deep packet inspection on a widespread basis without targeted suspicion of an individual user. It takes that entirely out of the equation and just allows them to garner a huge amount of data about what people are doing, with whom, and when. This is very intrusive, and it's a hell of a lot less efficient than targeted use of deep packet inspection for DMCA enforcement, and it's much more expensive to implement. Like I said, you don't need DPI to identify server connections, and ISPs are very reluctant because their business model is to an extent based on trust. People look at very strange websites, so they don't want to be essentially the gatekeeper to that data if they don't have to. So hitherto, they have been very reluctant to quote-unquote spy on their customers, and they do not want to garner an obligation amongst themselves to actually police activity. That's the whole point of the safe harbor provision under DMCA, is that they don't have to do that. So if they do this widespread monitoring, they essentially will be assuming that obligation. So why is this even a possible alternative? It seems totally crazy, but it's actually somewhat likely. The short answer here is money. So on 7 March, using something called the Congressional Review Act, just a few weeks ago, Senate Republicans, I think it was sponsored by Markey, had actually promulgated a scheme that was, in fact, just yesterday passed by the Senate to nullify rules that the FCC had promulgated that would have taken effect. So, in plain English, the FCC promulgated some rules. They sent out some rules that said ISPs are not allowed to spy on their customers. They're not allowed to review, things like deep packet inspection and monetize that data unless they have the explicit opt-in of a customer. And this turns this entirely on its head. So, by Congress nullifying the FCC's rules, they did it in such a way that if this passes the House now, the FCC will actually also be prevented from making further rules on the subject and overruling Congress. So, ostensibly, this nullification of very reasonable FCC rules, in my opinion, was designed to put ISPs on equal footing with website operators. Website operators, namely Facebook, Google, Snapchat, stuff like that, because they believed that it was very confusing for customers to have one set of rules that applies to an ISP and another that applies to Facebook and Google and whatnot that monetize our data on a daily basis. But obviously, we're all sitting in this room, and I think I don't have to preach to the choir, but there is a big difference about the usage of Facebook and data and then browsing history and what you're doing with any of your applications on your own network. So this just passed yesterday in the Senate, and it's going to go to the House. So it's something that I think we should all be monitoring quite closely. But obviously, there is a lot happening in the news lately, so this doesn't take front and center stage. FCC rulemaking abilities is not really a sexy topic. So how would this work, though? Because if they can monetize this, how would this fit into, let's say, a function of an ISP? Well, we've got a couple of very interesting concepts here, because if this goes through and ISPs can monetize our data, then a compliance function that was namely just an expense for an ISP could actually be turned into a revenue-generating unit, so to speak. And in so doing, the ISPs could appease the Motion Picture Association of America, utilize deep packet inspection, and then sell our browsing history, our application usage history, the metadata about with whom we are communicating at any particular time to third parties, to data brokers. In a sense, this could be sold to a data broker, and that data broker, let's say, especially if that happens to be a foreign entity, could then sell it back to the government. So, I'm not suggesting that this is the ultimate play by Congress, but it could be an end run around something like a warrant requirement, depending upon how the data is anonymized, if at all. But this would all happen at the expense of user privacy. It would be degraded, but according to Congress, no more so than our privacy is already degraded when we use Gmail, when we use Google, when we use Facebook. But there is a huge difference between our usage of social media and email and linking browser history to individual people, to individual families, and then monetizing that data. So far from putting ISPs on equal footing with website operators, I think there's a very reasonable argument that this nullification of the FCC's rulemaking process actually gives ISPs a huge leg up on people like Google and Facebook in order to monetize our data, because Google and Facebook only have data about Google and Facebook. Our ISPs have data about everything. Yes, speculative but possible. That's my point there. So what's happening already is quite interesting as well. So Kodi and Kodi boxes, as they are erroneously termed all around the world, and especially in the UK, there is already server-level blocking happening. And this is sort of an interesting story because this has to do with streaming services for live events in the UK. So the Premier League football teams are, this is what everybody watches in the UK. And a very popular place to watch football games are pubs. And pubs have purchased probably tens of thousands of illegal, quote-unquote, Kodi boxes, or boxes installed with Kodi together with unauthorized add-ons. And then instead of buying a subscription to, let's say, BT or Virgin Media in order to have access to these Premier League games, which can be quite expensive, as a matter of fact, they just stream them in and allow their patrons to congregate and drink and watch the football games. So BT, TalkTalk, and Virgin initiated a lawsuit. The lawsuit, coincidentally enough, I used to be chief compliance officer of a very large luxury group and worked out of London. And they utilized one of the cases that we had actually brought to the High Court on behalf of Cartier that required blocking orders for counterfeiters. And what the judge said was, based on the heels of that ruling, or rather maybe even on the shoulders of it, they ordered targeted blocking on a real-time basis of the servers that are streaming these live Premier League football games into the pubs. And so this is happening right now. As many of you probably are thinking already, you don't need a great level of technical skill to get around a blocking order like this. Simply pop out somewhere else, go, use a VPN, pop out into the United States, stream it through. So long as your ISP gives you enough bandwidth, you're good to go. But pub owners are not known for their technical acumen sometimes, so this may be somewhat effective. The efficacy, however, remains to be seen. Nonetheless, it is a very good time to be in the VPN business. So let's talk about that. So 3 general categories here: VPNs, proxies, anonymizers, and use of others' networks. Proxies and anonymizers have always been pretty effective at this, but they're not going to encrypt any of your packets going back and forth. Use of others' networks, at that point, who cares what happens to them? But this is sort of going back to the point that the EFF was making in their amicus brief to the Fourth Circuit, which is, if you are going to shut off somebody's internet service on the basis of some minor infringing activity, you may not even have real evidence that that particular person engaged in copyright violations. And there have been instances that we have researched in anticipation of this talk where, raids have been conducted. And then when the authorities show up, they realize, oh, well, this family had an unsecured Wi-Fi network, and this obviously wasn't them. But VPNs are going to, I think, be big business for people. They're going to be pretty effective to thwart at least, ISPs looking for targeted suspicion to then engage in DPI. But I think it's important to know that people who use a lot of these free VPN services don't realize that, in fact, they could be leaking a hell of a lot of data about their connections as well. And VPNs, as we just noted, are going to be probably quite likely effective at obviating these particular blocking orders as well. Because they're not targeting the, what the blocking orders do is they don't target the actual server that is doing the streaming. They tell the ISPs, you're not allowed to allow traffic from this particular server at this particular time. So if you go through a different ISP, you get around the blocking order. So a couple of conclusions here. copyright infringement, especially contributory copyright infringement, is going to be very costly if this decision is upheld by the Fourth Circuit. And there's going to be a lot of changes coming down the pipeline. Employee chatter is a huge issue. Repercussions are going to be tremendous for ISPs and quite likely for users with respect to privacy. The brave new world is Kodi and streaming services. It's definitely on the radar of the MPAA. We've already seen blocking orders. And if Congress has its way, we could very well see what was a rudimentary compliance function being turned into a revenue-generating unit for ISPs. And that's a very scary thing for us all. And I think we need to continually watch this. We need to be careful about it. And if things like deep packet inspection are going to be used on a widespread basis, users, internet service providers, users really need to speak up. And it's one of the things that I think remains very important, especially when all of our ISPs and cable companies are continually merging. So if we have only one choice, and they're utilizing widespread deep packet inspection monitoring for all of their users, we are sort of hurtling towards a world where there's widespread surveillance of all of our activities. It will very likely have a chilling effect, and I think that we could chilling effect on our freedoms of association and speech, and I could foresee very serious legal challenges coming from organizations like EPIC and the EFF against this kind of monitoring by ISPs. So in that sense, they may not want to spend the money on lawyers to defend it, but it could be a very, very lucrative endeavor for them. So I think that's all we've got for the most part. I'd open it up to any questions if anybody has any. You. Well, they could always get it for free by exercising a warrant, right? By applying for a warrant and having a judge sign off on it. But let's say that it could eventually end up to be an end run around the warrant process. So if you do not have probable cause to justify the issuance of a warrant from a judicial authority, then if you know that you can buy a large swath of data from a third party and then mine that data, you may then be able to generate probable cause to then go for a warrant on the basis of data that you probably shouldn't have had access to in the first place, but for you purchased it. So in that sense, it could be an end run around that. And data brokers, there's so many of them. And the stuff that they collect can be really pernicious, and they will sell to anybody. And I used to work in intelligence myself, and so there are, I probably shouldn't talk too much about it, but there are a lot of ways that governments can masquerade as private parties as well. And that also becomes a scary endeavor. So, as it stands now, my understanding is that the Congressional Review Act's nullification of the FCC's rules would very likely not restrict to whom they could sell this data, aside from people being on the OFAC list, or, the list of people that, you're not allowed to do business with because they support terrorism or any other sort of endeavor that's bad for the United States. So I could see this data running into the hands of, or getting into the hands of many third parties that would find it very valuable, and law enforcement is definitely one of those entities. Sir? Mm-hmm. Yeah, alt.binaries, .pictures, .erotica, yeah, I remember. Yeah, of course, yep. Mm-hmm. Mm-hmm.
So I think that could be outside with the permissible ISPs.
Right. Yeah. So if you didn't hear that in the back, he's saying, basically these Usenet groups that have existed since, the probably late 80s, early 90s, I think, are still being used to distribute files and quite effectively. And it's interesting. I haven't played with that a lot, but a lot of people have been telling me that these Usenet groups are really effective at distributing files. And that could be the way to go, utilizing SSL connections. So the stream of data is encrypted end to end. It's an interesting you mentioned that too, because that use of SSL, I'm not aware that it happens at all through any of these Kodi add-ons, but that would be one way of thwarting some of this deep packet inspection as well, in addition to VPNs. I could completely see that, but the problem is, so long as it stays somewhat low on the radar, or it has a threshold level of technical expertise that normal people cannot reach, once it becomes too user-friendly, things like Kodi, then it gets on the radar of the MPAA and the RIAA, and that's when you're going to see some sort of crackdown. But I think for now, you're right. This stuff has been around for a long time and is definitely off the radar, and it'd be very easy. It is very difficult to track, especially if you're connecting to these Usenets using a VPN as well. So I think it's an excellent point. But again, in response, if it becomes too easy, then you're going to see enforcement. Yes. Yeah. Absolutely. Sir.
The use of VPNs essentially just contributory or potentially even vicarious. If you even look at some of the use a VPN, they'll advertise a particular VPN
Yep.
use. Therefore, it becomes challenging for providers to not become maybe contributors.
That's a really great point. And if you didn't hear it, he's saying that, right now we're focusing on the contributory liability of the ISPs, and if the VPNs become the enablers of copyright infringement, you're going to see legal action taken against them. And that's an excellent point. They all advertise essentially in ways that make it very clear that they are designed to thwart legal process. We don't have logs. There's hundreds of users at any time on any particular server. No action could be traced back to you. All of this stuff. And quite frankly, it really is an excellent point, because a lawsuit against a VPN provider, these guys aren't huge moneymakers, right? So if they had to defend against a contributory copyright infringement suit and they didn't, let's say, have insurance to pick up the tab, just the defense of that suit could put them out of business. I could completely see that. However, I think that, there would be some legal precedent cutting the other way as well that VPN, providers could utilize, with respect to, let's say, registrars of domain names. We just provide a service. We give you a domain name. What you do with it is not, our thing. They could also then try to rely on DMCA safe harbor immunity, and essentially say, we're just a privacy service. And that's all we're all about, is privacy. But I would love to litigate one of those guys. I would love to defend that for a VPN provider. I think it would be kind of a cool suit. So thank you for that question. Sir.
Where would you place, based on what you just said, where would you place the remote activity software like TeamViewer, Remote Utility, WebEx, and all of them? Because I remember one time I was in Africa, I tried to order something using my PayPal account, and it was blocked because they picked up the ISP where I was. And all I did was to remote into my desktop at Clarion, and then I was able to carry out the transaction.
Yeah, that's exactly right. I mean, and other people can do this to other people's networks as well. I mean, TeamViewer is a pretty extensive attack vector for breaches. And I've seen it personally used for very malicious purposes. So you could have somebody team viewing into your computer. You're a 65-year-old woman. You don't realize you have TeamViewer installed so that the world can connect. And then your machine is used for copyright infringement. And then you're the person who's subject to termination of an ISP. And that's what the Electronic Frontiers Foundation's brief, I think, was hinting at. That you need to have more than this sort of, circumstantial suspicion about what people are doing on a network before you turn off their internet service. And so, yeah, like what you did was essentially, what you would do with a VPN. you're in Africa, you're in Ghana or someplace like that, you can't access PayPal, then you pop into the United States or a server in New York or New Jersey, and you then have access. When I lived in London, I had to do that before I moved back to sign up for Obamacare. So, yeah, I totally get it. Excellent question. Sir.
When it comes to like the active inspection, being able to sell and monetize the data, the rate at which certain content, and so from the perspective of those little guys,
Probably not, right? So, for anyone who didn't hear, and hopefully everyone did, I think a really excellent point was brought up that, once you're looking at application level data and you see what's going through the pipeline, you can begin to throttle that particular pipeline as well. Really, really great point. It's actually something I frankly hadn't thought about. And at that point, let's say an ISP is utilizing DPI and they find that there is an active connection to a server that's known to be used by Exodus to stream the Snowden movie. Then you can just throttle that bandwidth and make the stream completely unusable, and you destroy the viability of all of these particular Kodi add-ons. So, yeah, I think a really, really excellent point. And you had a follow-up question with that, or was it?
One thing I was also curious about is, like, in terms of, like, laying actual backbone, the internet, the wire. Of course, it's, like, a super expensive thing. Is there legality there? And say, like, look, we won't.
Yeah. Yeah. Yeah, so if they become the backbone and then have access to huge amount of data, then I think you have a very good argument for the widespread use of DPI to generate huge amounts of revenue for that particular company. And that's a dangerous thing too. And they could assuage our the privacy advocates by saying things like, well, we will anonymize it to a certain extent, right? But we know that anonymized data can be de-anonymized by reference, but by simple things like link analysis. So, that may work with the layman, but I think for real privacy advocates, for diehard technical people who understand how this works, we know that there's essentially full of crap. So I think that's a dangerous proposition, and I would hate to see deep packet inspection utilized in such a widespread basis. So, all the way in the back, sir.
Violation of Second Amendment rights.
The Second Amendment? First Amendment rights, yeah, exactly, yeah. Well, and by extension, the Second, right, yeah. It could be quite possibly. We know what's on your mind. Okay, all right, yeah. Don't sit next to him at lunch. All right. I think you're right. Because this is an interesting thing with surveillance, right? And going back to Snowden, this is an unpopular position to take, but I think what Snowden did, arguably, I'm not saying this is right, but what Snowden did by revealing the fact that the surveillance is happening, he actually caused the chilling effect from the surveillance. So if we know about surveillance, then we are going to change our associations. And that's how there's a chilling effect. So in the 1984 situation where we have telescreens and there's surveillance pervasively all around us, it's ubiquitous, we can't get away from it, and we know that, then there's going to be a chilling effect on our freedoms of association, the freedom of the press, and the freedom of speech. We're going to be very careful about what we say in any particular context when we know that there's monitoring, right? So would it be a good thing if we knew it? Then if we know about it, we're going to change our behaviors. If we don't know about it, then we can be caught for it, but at least we hadn't changed our behaviors and it had an effect on civil liberties. So, in the situation that the gentleman with the ponytail and the plaid in the back had mentioned, I think in that situation we probably would know about that particular type of surveillance because it would be surveillance through deep packet inspection, ostensibly through an ISP that is then bought and sold through other data brokers. So it'd be very easy, even if it was secretive, to uncover the fact that it's happening. And I think that could be really bad. I think we've got enough surveillance pervasively around us today, to keep us all busy. I don't think we need more. So, yeah. So thank you for that. Sir.
Where does net neutrality play? What role does it play in all of this then?
I have no idea. Yeah. Net neutrality. Sure. I think if the net neutrality rules were affected in such a way that, it would, that certain bandwidth would lean towards the big media companies and things. And again, it would essentially amount to a throttling of the particular servers that are used to stream copyrighted materials and things like that. So it would be probably another way that they could try to destroy the viability of these particular Kodi add-ons. The other guy in plaid. All right. Yeah. So if DPI became the norm, what are the countermeasures that Kodi is going to use? Sure. I mean, it goes back to one of the questions I think that we were answering as well, or actually a comment about Usenet. Perhaps what Kodi would do then is implement SSL, so that the connections between the streaming servers and the users were implemented through SSL, so it becomes more difficult to engage in deep packet inspection at that particular time. But again, to go back to deep packet inspection, we're talking about application level data. You're still going to get the TCP and IP level data. So unless they're constantly changing the location of these servers and then having the add-ons be made aware of the location of those servers, I think it's going to be tricky to not have an ISP get wind of the fact that a particular user, if they're monitoring, is streaming copyrighted content. Yeah. Anything else, guys? Well, great. I thank you guys so much for the really great questions. This has been a lot of fun to present to you. I'm Alex. This is my law partner, Justin, over here. Come talk to us. We'll be around. Thank you very much. Sure.